I ran across this video the other day and I realized this was the very first time that I followed a case from the very start to the very finish. And it was to celebrate 10,000 followers, which is pretty cool. Looking back on it, it didn't get a lot of views, so I think most of you haven't seen it. I was reminded of this recently when I found a story and posted it in the community section about a shaken baby syndrome and how controversial it is and that a man is on death row for it. There was a lot of similarities between this case and that. So I'm going to replay this one for you. I hope you enjoy it. On the afternoon of September 1st, 2022, a 911 call came in from the Blissfield Township in Lenawee County, Michigan. The report was of an unresponsive 2-month-old baby boy. The police chief was the first to arrive. He performed CPR on the boy until paramedics arrived, and they rushed the boy to the hospital in Toledo, Ohio. Just as the ambulance was arriving to the hospital, EMTs detected a pulse in the baby boy. The chief would later tell 13 ABC News they believed the baby was down for at least 45 minutes and maybe as much as an hour and a half, so the fact that they could get a pulse back was nothing short of a miracle. The child's father, Christopher Deathos, was arrested on charges of child abuse. The baby remained in the hospital for the following week, then unfortunately passed away on September 8th. The cause of death was listed as shaken baby syndrome. The Blissfield police were told by a doctor at ProMedica Toledo Hospital that the child's injuries were consistent with having been shaken, and Deathos told police he shook the baby when the baby wouldn't stop crying, according to the affidavit of probable cause filed in district court. An additional charge of homicide, open murder was added, and Deathos' bond of $500,000 was raised to $10.5 million. A competency hearing was set for January. In mid-December, his case was bound over to Circuit Court, which is where we pick up the case, in Lenawee County Circuit Court.
All right, Mr. Glazier, I have Mr. Deathos, but I lost him. Where'd he go? Oh, he's in. I lost him. Where'd he go? All right, well, I had him, but now I don't. All right, what was your name again? All right, Mr. Deathos, sorry I lost you.
I accidentally left the meeting. I forgot to put got it. I'm in the other room, so.
It's okay. It's okay. Let me find you. Not a problem. You said your attorney was Mr. Glazier, right?
Yes.
File. All right, in the matter of the people of the state of Michigan versus Christopher Nicholas Deathos, file number 22-21180FC. I have John Glazier appearing on behalf of Mr. Deathos, and I have Phoebe Meir appearing on behalf of the people. This is a date and time set for arraignment in this matter. Mr. Glazier, have you received a copy of the felony information?
Yes, I have, Your Honor. We'd waive the reading of that. Enter a plea of not guilty and ask this matter be set for a pretrial, Your Honor. We would ask that the court order an evaluation on criminal responsibility. It was ordered down at the district court, and I've been having a lot of problems with the state of Michigan on this. They do one, but they don't do the other. And sometimes they get the guy to waive it, sometimes they just don't do it. In this case, I don't know the reason why, but I definitely need a evaluation as to criminal responsibility. And after that, I'm going to have some independence done on both competency and criminal responsibility. So I think we're going to need some time on this, but I just want to make sure I get it the order. In fact, Judge Shaler said she was going to put it in again, but just to cover myself, I'd ask Your Honor to put in an ordering evaluation.
So I have an order dated September 13th of 2022 for evaluation regarding criminal responsibility.
Yep.
So
That was never done.
well, I understand that, but I don't think I need to order it again. I think you just need to send it again to the forensic center.
I can do that, Your Honor, but I've been having not very good luck.
We haven't up here either, to be honest with you, but so I mean, we have that order in place, so I would say just it's already ordered, so
Does everyone have the
just-
letter dated October 31st?
Okay, what does that say?
It just says there will be additional delays in scheduling the criminal responsibility evaluation because of the high volume of evaluation orders received by the center. Please know that the evaluation of the defendant's criminal responsibility will be performed as soon as possible. If you have any questions regarding the continued delay, then it gives a telephone number and email address.
Can you send that letter over to me? I apparently didn't get that.
Yeah.
all right. I don't have that in the file as well. It might be in the district court file.
Yeah, that's what I'm guessing, because it's titled to Judge Shadler. So I can send it to, you want me to send it to Ms. Adams?
Yes, please, and Mr. Glazier. And
Yeah.
I'll set this out for another pretrial. Let's do February 15th, just to see if we've heard anything. How's that, Mr. Glazier?
That's fine, Your Honor.
And that'll be at 8:30. I used to volunteer there, and they used to have a full staff of people that did these, and that was back, John, when we always got them right away, and then they went to part-timers and contract employees, and they're understaffed, and it's a mess. All right, so Mr. Deathos, we will see you back here on February 15th at 8:30 in the morning for a pretrial, all right? Sir, what is your name, please?
First name is Chris, last name is Deathos.
Right, hold on, Mr. Deathos. This is Mr. Glazier. So, and I'm waiting, oh, I got Miss Blaze. Forgot you were still there, Miss Blaze.
I gotta turn up
All
my
right.
volume. I can't hear anything.
Can you hear me now? Miss Weiss, can you hear us now?
Yes, sorry about that.
Not a problem. So this is in the matter of the people of the state of Michigan versus Christopher Nicholas Deathos, file number 22-21180FC. I have John Glazier appearing on behalf of the defendant, and I have Jacqueline Weiss appearing on behalf of the people. This is the time set for a first pretrial conference in this matter. Mr. Glazier, how do you wish to proceed? You're muted, Mr. Glazier.
Sorry about that. I just got last week a criminal responsibility ruling by the Health and Human Services. I need to have an independent done
Well, hold on a second, hold on. Did we place the criminal responsibility on the record? And the, or the cop?
That's not one you would put on the record. The competency had been put on the record well before. We just didn't have the criminal responsibility.
Okay. So you have that now.
Yes.
And so you're going to have an independent done.
I'm gonna have an independent done for criminal responsibility as well as ability, his ability to assist me at trial. We have a person we use. I don't know if I need an order, but I'll have an order prepared if Your Honor doesn't mind. And I'll put in the name of the person we use.
Do you have a
All
time?
right.
I'm here.
Ms. Weiss, what'd you say?
I just asked him if he had a time frame, like how long. I have no objection, obviously, to him getting an independent. I was just wondering if we have a time frame, looking out how far your guys doing it.
Independent are usually shorter than the state ones, which can take a year. So.
I've got to get a hold of the person. So I don't know. Maybe.
So what I suggest would be a May 3rd pre-trial, and if you need to adjourn it, you guys can just stick to adjourn it.
Okay.
Okay.
And Mr. Deathos, I got your letter. I will set up a Zoom conference to speak with you next week.
Can I speak to you in a breakout room real quick? I have something I'd like to speak to you about.
Yeah, I don't have a problem. If you can't, Judge, that's fine. I'm gonna talk to you next week, Mr. Deathos.
But can I give you my mother's phone number? She'd like to speak to you.
Yeah.
So hold on, everybody, hold on. So we're live on YouTube. So Mr. Deathos, I don't want any phone numbers being placed on the record. So
all right.
you just tell your mother to call Mr. Glazier, all right?
She doesn't have his number. That's why I had to give her.
You do on all your paperwork has the public defender's office.
Okay.
Or if she can't find it, have her call the courthouse and get the public defender number, all right?
All right.
Okay, so, all right, so we will set this out to May 3rd at 8:30 in the morning, and then Mr. Glazier, you can do the stipend order to adjourn.
Yeah, I'll do that too, Your Honor.
Okay, and then I'll sign the order upon presentation.
May 3rd at what time?
8:30. All right, you're all set, Mr. Deathos. You have a good day. Matter of People of the State of Michigan versus Christopher Nicholas Deathos, file number 22-21180FC. I have John Glazier appearing on behalf of Mr. Deathos. I have Jack Weiss appearing on behalf of the people. I have a March, let me see here, a March 22nd letter, 21 letter from you, Mr. Glazier, stating we have not yet received the criminal responsibility report. We still have it?
I don't know, Your Honor. I think I've received it since I sent that letter out.
We actually received that like January 31st. We had a hearing February 2nd, and on February 2nd, you asked for an independent examination.
Okay. I didn't have the original though when I looked in my file, so they sent it to me. I know I think I got it since that time.
Okay.
I think we got the original one that was done by the CFP, but have you gotten a report from your independent?
No, Your Honor, I need, what I really need is about a week to go down and talk to Mr. Deathos in person, if the court will allow me to.
Okay, so I don't have, all right, I can set it for May 10th. Is that all right?
Yeah, that's fine, Your Honor.
All right, so Mr. Deathos, I am going to set your pretrial over to May 10th at 8:30 in the morning. And Mr. Glazier, can you do the stipend order to adjourn?
Yes, I can, Your Honor.
All right, so Mr. Deathos, I will see you back here on May 10th at 8:30 in the morning, all right?
Your Honor.
Yeah.
On Deathos, there, I talked to Jackie last night kind of late, and so I haven't had a chance. As one, she says she has a pretrial on Friday. Could we adjourn this over to the same day as that?
She says who has a free trial?
She said she has a pretrial in front of you on Friday. And because I told her I needed to adjourn it like a day or two, and she asked, or I was wondering if we could adjourn it to the same day as her other
Sure.
pretrial.
Miss Adams, do I have a criminal pretrial on Friday?
Judge, I can jump in. We set Christopher Mauer for Friday at 11.
Do you want me to set this one at the same time?
Yes, please.
Yes, Your Honor.
All right, so Miss Adams, okay, so we won't take Mr. Deathos this morning. We'll set him for a pretrial on 5/12 at 11. Okay, thank you.
Thank you very much,
All right.
Your Honor.
You're welcome. Okay. People of the state of Michigan versus Christopher Nicholas Deathos, file number 22-21180 FC. I have John Glazier appearing on behalf of Mr. Deathos, and I have Jacqueline Weiss appearing on behalf of the people. This is the date and time set for a pretrial in this matter. Hold on one second. Let me check my breakout rooms. Sunwood's looking at me. Okay. Mr. Glazier, how would you like to proceed on behalf of Mr. Deathos?
Yes,
I
Your
see
Honor.
he's got his hand raised, Your Honor. Maybe he wants to talk with me.
Can I talk to my attorney in a breakout room real quick?
Yeah, so that's why I was asking Mr. Glazier. So Mr. Glazier, I'm gonna put you guys in a breakout room.
All right.
And there we go. I'm gonna open those rooms. Right, we're back on the record. So Mr. Glazier, if you had a moment to speak with Mr. Deathos.
I have, Your Honor. I've also spoke with the prosecutor, Ms. Weiss. Your Honor, I talked with Mr. Deathos at length yesterday down at the jail, and I thought we were going to ask to adjourn this out quite a while. He's had a change of heart since I talked to him, and I think we're probably going to work out a plea. The only thing I would ask is maybe we could adjourn it till next week, and Ms. Weiss and I, part of the plea would be a killability to the guidelines. I want to see if we can agree what the guidelines are.
All right, hold on a second. $15, $14, $15. Yeah, I can set this out to June 14th. So, Mr. Deathos, I will set your pretrial over to June 14 of 23 at 8:30 in the morning. Mr. Glazier will run your guidelines and have a conversation with Ms. Weiss in hopes that this can be resolved. So, Mr. Glazier, you'll do the stip in order to adjourn.
Yeah, I can do that, Your Honor.
All right, very good. Mr. Deathos, thank you, and I'll see you back next Wednesday. All right, so Mr. Deathos, you want to go up to the podium?
Your Honor, could I ask, this might take some time. Could my client do it from the chair?
No. You can sit, he can stand.
All right.
You don't have to stand.
Okay, that's fine.
All right, no, I just need him at the podium, not you. All right, so Mr. Deathos, okay, so this is in the matter of the people of the state of Michigan versus Christopher Nicholas Deathos, file number 22-21180 FC. I have John Glazier appearing on behalf of Mr. Deathos, and I have Jacqueline Weiss appearing on behalf of the people. It's because my court reporter faces you all this way to do a record, so it's easier for her if you're all there. All right, so Mr. Glazier, this is a date and time set for a pretrial. I have received an amended felony information Count 1, child abuse first degree. Count 2, homicide, open murder, and count 3, homicide, manslaughter. So, Mr. Glazier, how do you wish to proceed today?
Your Honor, we intend on entering a plea to count 1, the child abuse first degree, and to count 3, the manslaughter, with the understanding that count 2 would be dismissed at the time of sentence.
All right, is that a correct recitation of the plea, Ms. Weiss?
That's correct, Your Honor.
All right, so Mr. Deathos, you want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
All right, can you state your full name for the record?
Christopher Nicholas Deathos.
All right, so Mr. Deathos, you have heard the statement of your attorney and the prosecuting attorney. Is it your intention to plead guilty to count 1, child abuse first degree, which carries a maximum penalty of life or any term of years, as well as count 3, homicide manslaughter, which carries a maximum penalty of up to 15 years in prison and or a $7,500 fine? So is it your intention to plead guilty to both of those counts?
Yes, ma'am.
Okay. Are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
Yes, ma'am.
Okay. Neither the prosecutor, the defendant, nor anyone on the defendant's behalf has discussed a possible sentence with the court. Is that correct, Mr. Glazier?
That's correct.
And Ms. Weiss?
That's correct, Your Honor.
And
No,
Mr. D?
Your Honor, it's not correct. Actually, and I forgot to put this on, the prosecutor and I have had a discussion, and there would be a killable plea, Your Honor, that the sentence would be within the guidelines. And the prosecutor and I agree that the guidelines work out to be 11.8 years to 18.75. Is that right?
Yeah, I got 135 months to 225 months.
Yeah. And that the maximum would be a term of years to be determined by the court, not a life sentence.
All right, so you guys are stipulating that the guidelines are 135 to 225, that he will not be given a sentence of life, that he will be sentenced to a term of years. And
That's it.
that's it. There's not a kilogram that he would be sentenced within the guidelines, no.
Oh, yeah,
The
it
bottom-
is within the guidelines.
Within the bottom end would be within the guidelines, and then the top end, whatever the court determines.
Okay, so the sentence would be, okay. So anywhere from 135 months to a maximum of 225.
No.
Right.
No,
On the bottom end, yes, so it's, yes, but you could do whatever on the top.
Top end, you can do it, whatever, just it wouldn't be life.
I need a bigger postage. Here's the little one, bigger one. Okay, so we. So the plea would be the low end of the guidelines to whatever,
Term of years.
okay. So the 135,
No, it's
No,
not, it's not
It's
to
not the low
of
end,
the
it's
guidelines.
anywhere which,
Okay.
35 to
Within the
225 to whatever.
so, Mr. Deathos, do you understand that's part of the agreement too?
Yes.
Anything else, Mr. Glazier or Ms. Weiss?
No, you're right.
No,
Okay.
you're right.
So other than that, though, Mr. Deathos, neither the prosecutor, the defendant, nor anyone on your behalf has discussed any other possible sentence with the court. Is that correct? So treatment, whatever. Okay. Would you agree with that, Ms. Weiss and Mr. Glazier?
Yes, sir.
Yes, Your Honor.
Okay. If a guilty plea is accepted, there will be no trial. This means that you will be giving up rights you would have had at trial. I'm going to explain those rights to you now to make sure that you understand them. You have a right to a speedy public trial by jury. You may ask for a non-jury trial, and if the prosecutor and court agree, you can have a non-jury trial. You have the right to be presumed innocent until proven guilty beyond a reasonable doubt. You have the right to have the prosecuting attorney prove beyond a reasonable doubt that you are guilty, and you do not have to prove anything. You have the right to be present at trial and have witnesses against you appear at your trial and to ask those witnesses questions. You have the right to have the court order any witnesses you have for your defense to appear at the trial. You have the right to remain silent during your trial and not to have your silence used against you. However, you also have the right to testify at your trial if you want to testify. Do you understand that if your plea is accepted, you may be giving up the right to appeal issues that would have been otherwise appealable had you been convicted at trial. Do you understand that?
Yes.
Do you understand that any appeal from the sentence and conviction, from the conviction and sentence pursuant to the plea will be by application for leave to appeal and not by right?
That's done.
So if you had been convicted at trial, you would have had an automatic right to appeal. But because you're entering a plea, you don't have an automatic right to appeal. You would have to file paperwork for leave to appeal, and they would have to decide whether they would grant that or not. Okay. If you are not a citizen of the United States of America, a conviction of a crime may result in deportation, exclusion from admission to the United States of America, or denial of naturalization. Do you have any questions about the rights that I've given to you? All right. So Mr. Deathos, how do you wish to plead to the charge that on or about September 1 of 2021 in the village of Blissfield in the county of Lenawee, that you did commit the offense of child abuse first degree, guilty or not guilty?
Guilty.
And how do you wish to plead to the charge that on September 1 of 2021 in the village of Blissfield in the county of Lenawee, that you did commit the offense of homicide manslaughter, guilty or not guilty?
Guilty.
Okay. Has anyone made any threats or promises to you to induce you to plead guilty to these charges other than what was placed on the record? Is the prosecutor or defense counsel aware of any other promises or threats or inducements other than the plea bargain to induce the defendant to plead guilty? Mr. Glazier
No, you're.
and Ms. Weiss?
No, Your Honor.
Has your attorney, I mean, we put your basic sentence on the record, but other than that, has your attorney promised you any particular sentence or estimate what your sentence will be other than the agreement? Like treatment in prison or fines and costs or anything?
No.
All right, would you agree with that, Mr. Glazier?
I would, Jared.
All right, and is it your own choice to plead guilty to these charges? All right, so, Mr. Deathos, on September 1 of,
Can I ask if there's?
You wanna-
I
you
want
can do
on
it.
the record, then I could ask the factual basis after that.
that's fine, Ms. Weiss, any objection to that?
No, Your Honor.
All right,
Your Honor, for various reasons, I wanted to engage Mr. Deathos with some question and answer before I go to the factual basis. Mr. Deathos, you're aware that we had a criminal responsibility and a criminal competency exam done by the state of Michigan, is that correct?
Yes.
And you participated in that,
Yes.
and that took place for several hours. Was it one day or 2 days?
one day, I think.
Okay, and you are aware that you were found to be criminally responsible by the state of Michigan psych unit, as well as competent. You understand that that was their basis, and you've seen those reports. Is that true? Right. You don't think that was what the report said?
Oh, yes, I do. I'm sorry.
You and I met back just last weekend, June the 6th. We spent an hour or so going over various documents and forms and jury instructions, et cetera. Is that correct? You gotta say yes or no, because you're being recorded.
Yes.
All right. One of my concerns, and actually I knew this before the reports were done, was your father indicated you had a very low IQ. Is that true?
Yes.
And in fact, some of the documents that were presented to the state of Michigan shows that your IQ was actually, when you were 7 years old, the test reflected it was 51. 51, was that correct?
Correct.
And you understand that's very low.
Yes.
All right. Now, your father, who passed away
Yes.
while this is proceeding, advised me that you are quite capable of understanding things and communicating and expressing yourself. Is that true?
Yes.
I would also place on the record that I find him to be very capable of communication and understanding what I've been trying to tell him. I think.
Okay.
When I went down to the jail last week, I presented to you a plea bargain that was offered by the prosecutor. Is that correct?
Yes.
And in fact, it's the plea bargain that we put on the record here today. Is that true?
Yes.
And you understand that, and I didn't write down the exact months, but your minimum sentence is going to be determined by the judge. You understand that?
Yes.
And that will be within the guidelines.
Yes.
You understand that? And the prosecutor and I have them at, what is it again, month less?
135 to 225 months.
That your minimum sentence will be between those months. You understand that?
Yes.
That is roughly 11.8 years to 18.75, I believe. You understand that?
Yes.
That means when you come back for sentencing, the judge is going to set a minimum sentence that is somewhere between those. You understand that?
Yes.
So the earliest you'd be, and that's when you're eligible for parole. It's when you have served your minimum sentence. You understand that?
Yes.
So at the very earliest that you would be eligible for parole is going to be approximately 11.8 years. You understand that? Minus whatever time.
Is that
you served.
like 12 or so? Or?
Almost 12. But the judge could go up as high as almost 19, 18.75 years. You understand that?
Yes.
That's just your minimum sentence. That's where you become eligible for parole. You understand that?
Yes.
The maximum sentence on this could be up to life, but we have agreed it'll be a term of years. You understand that?
Yes.
What that means is that if they don't grant you parole the first time, second time, the third time, the fourth time, there's going to be a maximum that you could serve if you don't make parole. You understand that?
Kind of. What do you mean?
Okay, you're going to have to serve at least a minimum of, let's say the judge picked 12 years. That means you're going to have to serve at least 12 years, at which time you'll become eligible for parole. You understand that?
Yes.
You'd apply for parole, you'd have a parole hearing. If you were granted parole, you would get out on parole following the hearing. You understand that?
Yes.
Now, they could deny your parole, which is called flopping. You've heard them say flop. That's basically having being flopped, and then you become eligible for parole again. And it's not a homicide, so I'm not sure what it is, but it's at least every 5 years. It might be quicker than that. And so then you'd apply again in 5 years, get parole, you're out. If you don't, keep going. If it went all the way up to the maximum, they'd have to release you. We don't know what the maximum is because the judge is going to set that when you get sentenced. You understand that?
Yes.
I asked her and we agreed that it would not be a life offense. My sole reasoning behind that is I know the parole board on second-degree murders where it is a life offense are less likely to parole you. And so I didn't want anything that said life offense is the maximum. You understand that?
Yes.
So to summarize, you're going to get a minimum sentence between almost 12 or to a little less than 19. That's going to be your minimum. And your maximum is going to be a term of years that the judge is going to set. Okay?
Yes.
You understand that?
Yes.
Now, when I talked to you at the jail, and I also talked to you here today, I advised you that I could get an independent evaluation done as to your competency and your criminal responsibility. Is that true?
Yes.
And you understand that would not be by somebody from the state of Michigan, that would be by somebody that I choose that I would hire.
Correct.
And they would reevaluate your competency to stand trial as well as your criminal responsibility, Ms. Van. Do you understand that?
Yes.
Regardless of what those findings are, you would have a right to a trial. Do you understand that?
Yes.
And if my independent evaluator said, hey, you weren't criminally responsible, or you weren't competent, that would be an issue or criminally responsible, excuse me, that would be an issue raised at trial. Do you understand that?
What does that mean? Like,
That means if we went to trial, you could present, it's sometimes referred to as an insanity defense. But that because of a mental illness, you don't appreciate the wrongfulness of your acts, basically. And it'd be a fight between the state of Michigan and our expert if he deemed you to be not responsible as to whether you're not guilty by reason of insanity. Do you understand that?
yes.
But likewise, the jury could still find you responsible and find you guilty of child abuse first and open murder. Do you understand that? first degree murder.
Yes,
And you're choosing not to have that evaluation. In fact, I told you that's what we were gonna do, and you told me, I think last week and again today, that you don't want to have those evaluations done. You want to proceed with the plea record. Is that correct?
yes,
All right. So just so you understand, and I want to make sure you understand this, and it's kind of tricky. You're charged with open murder, but there's a charge that is referred to as felony murder. I've explained that to you.
yes,
Okay, basically what felony murder says is that if you commit a murder, if someone dies by your acts during another crime, and the crimes are listed within the statute, that you are guilty of first degree murder, could be found guilty of first degree murder. You understand that?
yes,
Right, and I've explained to you that one of those crimes is child abuse in the first degree. You understand that?
yes,
So if you went to trial and a jury found you guilty of child abuse in the first degree, they could find you guilty of felony murder, which is first degree murder. You understand that?
yes,
And first degree murder carries life without parole. I've explained that to you.
yes,
So that's the risk for you, is if they find you guilty, if a jury found you guilty of child abuse in the first degree, they could find you guilty of felony murder, and you could face life without parole. You understand?
yes,
That's not to say they would, but that's what the risk is for you. You understand that?
yes,
All right. Now, I've explained to you, child abuse in the first degree requires a jury they don't have to show intent, but the prosecutor would have to show that you knowingly or intentionally, which would be intent, but knowingly cause physical harm to a child, serious physical harm to a child. You understand?
yes,
All right. And you don't wish to take that risk and want to take the plea bargain at this time.
yes.
Do you have any questions or of either the court itself at this time that need to be answered?
Not at this time.
You understand everything that we've gone over, both at the jail and tried to put on the record here today.
Yes,
And you still want to proceed with this plea, is that correct?
yes,
All right. I'm gonna ask you some questions about on the amended information. You understand, I'm gonna show it to you. This homicide is gonna open murder, which could be first degree murder, is gonna be dismissed at the time of sentencing. All right, what you're pleading to is count 1, child abuse first degree, and count 3, homicide manslaughter. You understand that?
yes,
All right. We'll go over a couple things. On September 1st of 2021, were you watching or taking care of your son?
yes,
And that is Weston Deathos?
yes,
And at that time, he was born on June 23rd of 2022, is that correct?
yes,
So on that date.
Well, hold on a
Yeah,
second.
he couldn't have been born after the date of the offense.
The date of offense is September 1 of 21.
Did I say June 23rd?
You said 2020.
I think it was this
June 23rd.
last year, the
June
23rd.
23rd, 2022 is what I meant to say.
Right, you keep saying 22. It's not, he couldn't have been 2022 because he had to have been born before the offense date, John.
Oh, okay, I didn't notice the offense date. Well, that's his date of birth.
What day was your child
Maybe
born?
your offense date's from.
June
Yeah.
23rd, last year.
2022, so
The-
the on or about, can I amend it to September 1st, 2022? So the information is incorrect.
Are you gonna amend that today?
Yes.
And we have no objection.
Sorry, John.
So it's September 1 of 22.
Yes.
All right, we'll go back to Mr. Deathos, your son, Weston Deathos was born on
June 23rd,
June 23rd of 2022, is that right?
yes,
So on the date of September 1st, we got that date right, because the date of death is September 8th.
September 8th.
that date wrong also?
Yep, September 8th.
So we need to amend, that to September 8th of 2022. What's that?
I guess so. What are we doing?
Changing the date to honor about September 8th instead of September 1st.
So September 8th of 22?
Yes. Mr. Deathos, on September 8th of 2022, your son would have been about 2 months and a couple of weeks old. Is that correct?
Correct.
And you were caring for him at that time?
Yes,
And the mother was gone and you were you were
the sole
providing
caregiver.
the
She was at some kind of class that she had to take out in Adrian by the college.
All right. And the child became upset and was,
I had a mental breakdown.
I understand that, you understand that you're, by pleading, you're giving up any type of defense, saying a mental breakdown caused this, it caused you to have, injure your child, you understand that? The child was being fussy or acting out, or it got you frazzled, is that a fair statement?
What's frazzling?
Upset or
Yes.
nervous?
Yes,
Okay, and as a result of that, you grabbed your child and shook the child rather violently, is that correct?
yes,
Now, you knew that shaking the child in that manner could cause serious physical injury, is that true? And as a result of that, your child eventually did die from being shaken, is that correct?
yes,
It was. And this all occurred in Lenawee County here in the state of Michigan, is that true?
yes.
You're absolutely sure this is the way you want to handle this today?
Yes.
I don't have any other questions.
Any other questions, Ms. Weiss?
At the time that you shook the child, you intended to shake the child to get him to stop crying?
I didn't want, yes. I didn't mean for him to pass away though.
And nothing further, Your Honor.
Ms. Weiss, could you also, do the amendment, correct the first name of the child in count 3?
Yes, and I looked at the report and it looks like the death certificate listed date of death is September 8th, but it's all September 1st, 2022.
So the event occurred, but the death certificate was dated September 8th.
The death certificate lists the date of death as, so
It's,
that may be an error.
that's from the coroner's office, yes, but the actual date is September 1st, 2022. So I'm going to leave the September 1st date on there.
That's fine. I was just asking questions based.
No, no.
Yeah.
on date of
I
death.
Okay, Ms. Weiss, is there anything else you wanted to add to that or ask Mr. Deathos?
No, Your Honor.
Has court complied with MCR 6.302 B, C, and D?
Yes, Your Honor.
Yes, Shirley.
All right, and I accept the pleas. They've been given understandably, voluntarily, and accurately. The defendant has full knowledge of his rights. He does have competent counsel. Mr. Glazier, I appreciate you going through all of that to make sure Mr. Deathos comprehends what he was entering into in the plea. So there is a Killebrew agreement to the sentencing range in a term of years. But other than that, the court has made no agreement regarding the possibility of a plea or possible sentence in this case with the prosecutor, the defense attorney, the defendant, or anyone acting in the interest of either of them other than the Killebrew. I'm going to refer this matter to the probation department for a pre-sentence investigation. Are you both available July 27th at 8:15?
I believe so, Your
Yes.
All right. So I'm going to set sentencing for July 27 at 8:15 in the morning. Mr. Glazier, would you like your client to appear in person?
Yes, I would, yeah.
Okay.
Did you say 8:30?
8:15. I do 8:15. So, Mr. Deathos, I will set this matter for sentencing on July 27 at 8:15 in the morning. Now, someone from the Michigan Department of Corrections, a probation officer, is going to come speak with you over at the jail. When you meet with him, be truthful about your background, be truthful about the events that occurred.
That led up to what happened.
Just
Not every-
talk about your background, be truthful. They'll ask you a bunch of questions. So be honest when you talk to them. They'll ask you about what occurred, be honest about what occurred. They'll prepare a report. We'll get a copy of that report to Mr. Glazier. Mr. Glazier will meet with you beforehand and review that with you. And then you'll come in front of the court that day for sentencing in person, okay? Mr. Glazier, any other?
Your Honor, the only thing I don't know if the court would want the probation, or at least the court, I'm gonna ask you to consider is maybe some mental records and evaluations. I can provide those.
You can provide those to Ms. Weiss for his mental
I
health
think she has
background.
probably the same things I do, but I will.
I mean, the probation department will always seek those medical records, so, and that information for the PSI, so you can provide that to the Michigan Department of Corrections if you would like, Mr. Commissioner.
All right.
All right, is there anything else we need to address on the record today with Mr. Deathos?
No, thank you.
No, Your Honor, thank you.
Okay, so Mr. Deathos, we will see you back on July 27 at 8:15 in person. Thank you.
Here's what you want. This is where we're at.
Yes.
First one she sent.
Jail, waiting rooms. Okay. All right, this is in the matter of the people of the state of Michigan versus Christopher Nicholas Deathos, file number 22-21180FC. I have John Glazier appearing on behalf of Mr. Deathos, and I have Jacqueline Weiss and Douglas Hartung appearing on behalf of the people. So this is a date and time set for two things, actually. One is a motion to withdraw a guilty plea that was filed with the court on June 21st. And I do have the response that was filed by the people. And then it's also the date and time scheduled for sentencing in this matter. Mr. Glazier, I presume you'd like to address the motion to withdraw the guilty plea first.
Your Honor, I've spoken with my client.
Can you stand at the podium?
It's hard for me, but I can't.
Okay, that's fine.
Your Honor, my client got a hold of me after the motion was filed, and he asked to withdraw the motion. And I want to make sure that this is something he's doing.
Mr. Deathos, want to raise your right hand for me? Do you solemnly swear or affirm to tell the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
Can you state your full name for me?
Christopher Nicholas Deathos.
All right, Mr. Glazier, do you wish to inquire with client?
Yes, sir. Mr. Deathos, we were in here and entered a plea in this, on this charge. I forget the exact date. What date was the plea?
Looks like we pled on June 14th.
On June 14th. Do you remember being in court when that occurred?
Yes.
And I asked you a long series of questions. I think I took 10, 15, 20 minutes where we discussed your options, the plea offer that's been made to you. Some of those options included having our own independent evaluation, adjourning us out, getting that evaluation done and go from there. Did you, is that correct?
Yes.
And you understood that? You still understand?
Yes.
You understand that if we proceed with this motion and the judge grants the motion to withdraw, that we could still be able to do that. We would have a independent evaluation done. And if the judge didn't set aside your plea, we could always appeal that decision. You understand that?
What's that?
That means if we asked, we filed a motion to have this plea withdrawn. The prosecutor's objecting to it. And I don't know the reason, well, I guess I know the reasons why, but I don't agree with their reason. But if we went through with the motion and the judge denied it, she sided with the prosecutor, said, no, you can't withdraw your plea. You understand, we could appeal that decision, and the Court of Appeals could very likely allow you to withdraw your plea. You understand?
That means get it back.
I'm sorry, sir, you'll have to speak up.
That means get it back.
Take it back, that's right.
Yes, I understand.
And you don't want to do that.
I do want to take it back, yes.
Oh, no, excuse me, you do want to take the plea back.
Yes.
Okay. I'm just saying, you understand that if the judge denied your motion here today and we didn't withdraw it, that you could appeal that decision of her not granting you your motion. Okay, and you don't.
I can't hear him and neither can my court reporter, so we can't make, maybe you can sit, but Mr. Deathos, okay. Could you re-ask that question?
Yeah. You understand that if we proceeded with this motion, and let me ask the way I did originally, and the judge granted it, we could then do that independent evaluation and proceed from there, have a trial or whatever we could do from there. You understand that?
Yes,
Now, if the judge were to deny that motion and the prosecutor is objecting to it, you would have a right to appeal that decision by the judge. In other words, that she wouldn't let you set aside your plea. You would still be able to appeal that decision. You understand that?
yes.
And you don't wish to do either of those things at this time, is that correct?
Right, I would like to continue with
sorry.
sentencing.
Wait, no, could you speak up?
Yes, I would like to continue with sentencing.
Okay. Is there, let me ask you this, why did you make that, you made that request the same day that you took the plea? At least that's when your letter was dated to me. What caused you to file that letter to ask to have your plea set aside, you know?
I was underneath a lot of stress and I realized I
I-
didn't.
You gotta, all right, so
I
Mr.
really-
Deathos, why don't we do this? You go stand at the podium, because you're very soft spoken.
Okay.
So it's not, but Mr. Glazier, let him answer your questions.
Why did you send me that letter requesting that?
I was underneath a lot of stress and I didn't make the right decision after the fact. I knew I screwed up and I wanted to plead the whole entire time. I wasn't, just a whole bunch of stuff was going through my head.
Okay, were you getting advice from people in the jail?
They came right up to my door and started, and it got me overwhelmed, and that's when I made the wrong decision and sent, and that letter went through. And I didn't, and after the fact, I lost the opportunity to get the letter back, and that's where I'm at right now. But I do
When I
want
say people, we're not talking about,
multiple people, no.
not people that work at the jail, you're talking about inmates, other
Yes.
inmates, is that correct?
Yes,
And you feel comfortable withdrawing your motion to set aside this plea and proceed to sentencing today, is that correct?
that, yes,
I don't,
Okay, all right, so Mr. Deathos, you're asking that the motion to withdraw your guilty plea be withdrawn.
that means take it back, correct?
Well, okay, so you had asked your attorney to file a motion to withdraw the plea that you entered on June 14th, correct?
Yes, Your Honor.
Okay, so do you want to continue to sentencing today, or do you want him to argue the motion to withdraw the plea?
I want to continue with sentencing today.
So you don't want to take your plea back?
Yes, I do want to take my plea. Am I not understanding?
it's kind of tricky.
It's kind of tricky.
Yes.
So we have a motion to withdraw. You pled guilty the last time we were here to child abuse first degree and homicide manslaughter, correct?
Yes. Your Honor.
Okay. And then you asked Mr. Glazier to file a motion to withdraw your plea. Do you understand that?
Yes, Your Honor.
Do you want me to hear that motion today?
I would like to take the plea back.
Okay, okay. All right, so Mr. Glazier, are you ready to argue?
I don't think he's still not saying it right.
Your Honor, Mr. Deathos, you want to cancel the withdrawal motion?
What
You
is,
want to cancel the motion to withdraw your plea? right?
Yes, I want to take my plea back. Basically.
You want
cancel the-
to go forward with your plea,
Yes,
and you want to have the judge sentence you today based upon the plea to the charges of child abuse first degree and the manslaughter charge.
yes,
This is your voluntary decision to do this.
yes, no one else but my.
No one's coerced you or put you in duress to make this decision today.
No,
We're satisfied, Your Honor.
Do you have any questions, Ms. Weiss?
No, Your Honor.
Okay. So you want to be sentenced today?
yes,
Okay. All right, so,
Your Honor, may I? So when we set the sentencing date, the mother of Weston got ahold of me. It's today's her birthday and she said she couldn't emotionally handle it and asked me to move the date. And I was under the impression that we were just having a motion hearing, so I didn't need the request to move it. And I didn't hear from Mr. Glazer that he was going to withdraw the motion. So I'm requesting to move this date to give the mother the opportunity to appear at sentencing. If we can even adjourn it by a week, Your Honor.
is there anything else?
No, Your Honor, thank you.
All right, so Mr. Glazer, I can move this to next week if you'd like, if you have any objection.
My client just wants to do it as quickly as possible.
I understand that, but victims do have a right to speak. And because the motion was on,
Can we do it tomorrow?
If I can get a hold of her.
Ms. Adams, could I see the book for tomorrow?
Sure.
Judge, my client thinks there was a victim's impact statement too.
That-
We never received a copy.
there was the paperwork that he showed me stated that there was a victim impact statement sent to Brittany.
All right, do we have a victim impact statement?
You know, I think it's just the one from the crime victims unit. I can show it. I don't think it got attached. It was supposed to. I'll show it to you. It's just the notice of the amount they were requesting. You want to see it, Judge?
No, you can show it to Mr. Glazer first.
I didn't get one.
So I can set this over till tomorrow.
This vehicle, that's all. It wasn't from her. It just showed that
The amount.
what they spent.
Do you want to, so I can set this for tomorrow and then Miss,
Your Honor, my mother, I can't hear her, but I'm assuming she said she can't show up tomorrow, but if,
okay,
I mean,
so I can do it another day, hold on. So I can do Tuesday.
next week.
I'm not gonna do it today, so
How far you going?
we are live on YouTube. I mean, I don't know, but I can't, by law, victims have a right to appear. And because there was a motion to withdraw, the people thought that's all we were doing today. So I can do it. I can do it August 2nd at 1:30.
Is that a-
I don't know, Mr. Hartman just left. Is he checking on something or just leaving?
No, just left.
All right, what about August 2nd at 1:30? That, they're an hour and a half away, that gives them a little bit later to drive. Ms. Weiss?
Yes.
Okay, so we will,
Yes, the second from August at 1:30.
yep, so I'm gonna set this over to August 2nd at 1:30 PM. And the motion to withdraw plea is withdrawn. So we will see you back August 2nd at 1:30, and that'll be in person. We're stepping across, there it is. So we'll make sure to note that that's in person. Okay, anything else we need to address today?
No, thank you, Your Honor. I appreciate that.
Thank you both. Everyone, yep. This is in the matter of the people of the state of Michigan versus Christopher Nicholas Deathos, file number 22-21180FC. I have John Glazier appearing on behalf of Mr. Deathos and Allison Arnold appearing on behalf of the people. So this is a date and time set for sentencing. The last time you were here, Mr. Glazier, your client had, after you very thoroughly questioned him on the record, asked to withdraw his motion to withdraw his plea.
That's correct, yeah.
Okay, so, and, Mr. Deathos, and you have discussed that further, and
I have, I just would indicate for the record, Your Honor, when I was here the last time, his mother was here, and I had never spoken to her. And she asked me out in the hallway what the motion was and all that type of stuff. And she says, what was my recommendation? And I told her, my recommendation is that he should have had an independent evaluation done all along. She told me that she believed she had talked Christopher into taking this plea and to not withdraw this plea. But I want to make sure, Christopher, you want to proceed to sentencing.
so Mr. Deathos, can you raise your right hand for me? Do you solemnly swear or to tell the truth, the whole truth, and nothing but the truth?
Yes.
All right, Mr. Glazier, you may proceed.
I'm going to ask you this quickly. So when we were here last time, we went over in great detail the plea, the sentencing and all that type of stuff. And you said you wanted to not withdraw your plea, you wanted to proceed with sentencing. Is that still true today?
Correct.
Did your mother have some sort of influence on you in making the original request to take the plea or anything of that sort?
This is all on me. This is my decision.
Right. I'm comfortable with that.
All right. All right, so, Ms. Arnold, is there anyone that wishes to speak today?
Not to my knowledge.
Okay. All right, so, Mr. Deathos, have you received a copy of the pre-sentence investigation report?
Yes, but I do not have it with me.
You don't need it with you, but you did receive a copy to review, correct?
Correct.
All right, and did you have an opportunity to read and review that and discuss it with Mr. Glazier?
Last week, right?
Yeah.
Last week, yes.
Yeah, so I think you actually were back in a room and Mr. Glazier talked to you about it?
Yes.
Okay, and do you feel he answered any questions that you might have had?
Yes.
And you thoroughly understand the pre-sentence report, and what it contains?
To my best ability, yes.
Okay. Do you have any further questions about the pre-sentence report?
What she was asking is it accurate? You've read through it.
I went over that probably more than 5 times sitting.
Oh, good.
Is there anything glaringly wrong or anything you noticed that
Just
was?
like striking kind of weird.
Yeah,
No,
Yeah,
no,
you-
no, I mean,
other than recommendations, is there anything you disagree with?
no,
All right, are you satisfied with Mr. Glazier as your attorney and the advice that he's given you?
yes.
Okay. Mr. Glazier, do you wish to explain or challenge the accuracy or relevancy of any information in the pre-sentence report?
No, my client says it's accurate.
Ms. Arnold?
Judge, not with the report itself. I did go over the offense variables and
I haven't gotten there yet. so
Oh,
give me
yeah,
just a
okay.
minute. Okay.
I don't know your routine yet.
Okay. Does the pre-sentence report disclose any prior convictions, Mr. Glazier, in which there exists any constitutional defect? I show he has no prior
I
convictions.
don't think he has a criminal history at all.
All right, now we'll go to the guidelines. So I have received today guidelines, a new SIR. So let's see here. So originally, the guidelines I had, check this. The original guidelines that came with the pre-sentence report for the child abuse charge, the original sentencing guidelines were 29 to 57 months. And on the homicide manslaughter charge, the guidelines originally computed were 135 to 225.
Just you've got that flipped. The child abuse first degree is the A felony. That's the higher.
Oh, okay. All right, let's see. I wrote it in the wrong place then, probably 29 to 57 on homicide. Yep, and 135 to 225 on the child abuse. Now I received an updated SIR from Ms. Holly today. And on this one, on the homicide manslaughter, the guidelines are calculated to be 19 to 38. And then the guidelines on the child abuse first degree were calculated at 135 to 225. I do have in my file that the prosecutor and the defense attorney at the time before the plea had computed the guidelines to be 135 to 225. So with regard to these guidelines, Mr. Glazier, do you dispute any of the PRVs or OBs?
Your Honor, I want to put a general complaint on the record is what I want to do. I was set and then, excuse me, she turned my phone down in court. Hold on. I was given this by the probation department about 15 minutes ago and said, well, don't worry about it. It keeps the guidelines the same and it really does, it just changes a few things.
I have time if the three of us want to go back and go over the guidelines real quick.
That's not the point, Your Honor. The point is, if they're gonna do that, I just wish they would give me some notice. I've talked with my client and I said, I probably could have adjourned this and come back for a sentencing. We've already adjourned it once for the victim to be here, and that's why we're here today, or the mother of the victim to be here today. I gotta believe that the scoring probably does benefit my client a little bit, although I don't remember what OV7 is or OV7.
I seriously, 5 minutes in the back room, we can go through these guidelines and resolve. I don't want any outstanding issues hanging.
I just should put on record, Your Honor, I asked my client if he wanted to adjourn so I could spend more time on these. And he said, no, he wanted to proceed.
So Ms. Arnold, Mr. Glazier, and Ms. Holly, you guys go that way into the jury room. I'm gonna get my updated sentence and guidelines book, and I will be right back there with you.
All rise.
All right, you can be seated. All right, so we are back on the record. I was able to have a thorough conversation with Mr. Glazier, Ms. Arnold, as well as Ms. Holly from the Michigan Department of Corrections, and we reviewed the changes from the original guidelines to the ones that were provided today. So we reviewed the ones that were scored today, and Mr. Glazier, would you agree at this time that these guidelines are scored correctly?
The new ones, yeah.
Yes.
Yes, yeah.
Okay, very good. So, all right. So we have no one that wants to speak today. So Mr. Glazier, is there anything you'd like to say on behalf of Mr. Deathos? Other than Ms. Arnold, I'll give you an opportunity at the end, but you did not have a victim there. Mr. Glazier.
Yes, Your Honor. I would just indicate that the guidelines in this case, I tried to make it real clear to my client what the guidelines were. There was a Cobb's plea that this would be within the guidelines. And I gave him these exact guidelines as what it would be, what the guidelines would come out at. So he was aware of what was going on. It's just, this is an unfortunate situation, Your Honor. If you read the PSI, you'll look and see that my client, it was a situation where the mother talks about how Christopher does not have a lot of experience with babies. This is his first child. She's been trying to teach him how to care for a baby. She stated she has never seen Christopher become angry when frustrated. It's a situation where he was not even supposed to be watching the baby that day. It was going to be not his mother-in-law, but actually his girlfriend's mother was, and something came up, and so he ended up having to watch this baby on his own, which for a normal person doesn't sound like a big problem. Most people can handle a baby. The situation with my client, Your Honor, is he's a 51 IQ, and I don't see where, I think that's referred to the police report. If not, you can look at the psychological evaluations, and it puts what his IQ is in it. If you run the test that was given to him at that time, that puts him at the level of an imbecile. He's characterized as an imbecile under that IQ test, a score of 51. He doesn't have a lot of control over some of the things he does. You know? He's always had some limited learning abilities and coping abilities and all sorts of things throughout his life. If you want to hear him in detail, his mother's here and she'd be more than happy to explain to you all the problems he's had growing up as a child and as an adult. They've done the best they can to treat him as an average, ordinary child. And that's one of the reasons when he communicates, he talks fairly well. You would never guess that he has these limitations. I was quite surprised when I saw what his IQ came in at. I guess the point is, Your Honor, you can see he's taking medication on page 3. That's where I was reading from before. For his issues, but nobody, the prosecutor, or not the prosecutor, the probation department recommends 15 years to 50, which is within the guidelines. I can't imagine that he wouldn't parole out early, parole out on time. This is not a vicious murder or a vicious child abuse case or anything of that sort. It was a situation where if a jury finds, not that he intentionally, but that he knowingly caused harm to a child, that could be bootstrapped into a first-degree murder, and he'd never get out. He'd be in there for the rest of his life. And he knew, and I think he knows, and I think he understood that he couldn't risk that, and that's why he took this plea. Against my advice, I still would have preferred to have had an independent evaluation. That being said, Your Honor, my client has suffered as big a loss as anybody in this case. Now, granted, it was because of some circumstances that he was responsible for, or at least that he couldn't control, and that's unfortunate. But he's lost his only child, Your Honor. His only child is dead because of the mistake that he made. And that's a hell of a punishment. We would ask the court to go to this screams out to be at the low end of the guidelines. This should be the 11 years, 7 months, or 10 years, 7 months, whatever it comes out as the number of months under the guidelines. That's when he should be eligible for parole. And if for some reason the parole system doesn't parole him out quick, I just can't imagine him spending 50 years in prison for this, for a mistake on his part. It's tragic, not only for the mother, who I guess isn't here today, and for obviously bad for the child. It's bad for everyone, but it's likewise very, very bad for my client. And I'm sure he can barely stand it. I don't have any of this.
Mr. Deathos,
Yes,
is there anything you'd like to say on your own behalf?
I wish Brittany was here so I could apologize to her, but I can see she's not in here. I wish her nothing but the best, and I'm so sorry for what happened.
Ms. Arnold, anything on behalf of the people?
Oh, no, thank you.
In determining the appropriate sentence in this case, the court has considered the seriousness of the offense, your history, the principle of proportionality, statutory penalty, cost of confinement, sentencing guidelines, the report and recommendation of the probation department, as well as what has been said upon the record at this hearing. Ms. Adams, I do not have notice of right to appellate review.
Okay, sorry.
The criteria and the reasons for the sentence are the nature and gravity of the offenses, the discipline appropriate to its commission, deterrence against repetition by you and by others, the potential for reformation, vindication for the law, and the protection of society. These are the very worst of the cases that come in front of the court and that the attorneys have to represent anytime a life is lost. It affects everybody, but most importantly, the people who lost. And in this case, Mr. Deathos, you also lost a child due to your behavior, and the mother lost a child, and looks like she probably couldn't even come to me. So based on the fact she probably just can't deal with this either. It's like, I see your client struggling as well, but I do see people in the courtroom, so I'm assuming her family members are here in support. And then Mr. Deathos' family is here as well. Sentence of the court that you serve a sentence with the Michigan Department of Corrections of 156 months to 600 months for the child abuse charge, and 4 years, 9 months to 15 years on the homicide charge. Those will be served concurrent. We have an updated credit.
Yes, 334 days.
Credit for 334 days. And I can order restitution here today.
Yes,
Okay,
I didn't have, oh, yes, I did, yes.
okay. I've just not had that before. Ms. Arnold, do you have any input on that? I've not had that happen before, and I'm sure Ms. Holly's right. I've never had restitution.
Yeah, I thought it was typically ordered as a condition of parole, but I don't think it's.
So what I'm going to do is I'm going to order $130 crime victim rights fee, $68 state costs, $60 DNA fee. As a condition of parole, you'll be required to pay $1,370 in restitution to the Michigan Department of Health and Human Services. There'll be a state supervision fee of $30 per month without monitor and $60 with monitor. And during, under the jurisdiction of the Michigan Department of Corrections, you'll obey and comply and complete all programming recommended. I know that for all the family members here, I mean, I lost a brother. There's nothing like the loss of a child. So I recognize how hard it is for everybody. And I'm sorry for everybody's loss. These cases just don't ever get better, and I'm sorry. So Mr. Deathos, you do have the right to appeal this sentence. My bailiff's going to hand down to you 3 copies of your notice of right to appellate review. I want you to initial and date 1 copy for my records. That's just to let me know that you received your paperwork. So go ahead and do that.
56, well, she found her. Yes, you would, was that 13 years? She did.
So, yeah, Mr. Deathos, I didn't exceed the recommendation. So you signed that one just to acknowledge you received your appellate paperwork. If you decide that you want to appeal my sentence, you would fill out the information on that paperwork. You can do it today. You can do it and have it sent over by kite from the jail if you want, or you take it with you to the Michigan Department of Corrections, but you have 42 days. If you decide you want to appeal my sentence, you would fill out the information on the form and mail it to the address listed on the form within that 42 days, all right?
Okay.
Like I said, you can do that before you leave today if you want. I wish everybody healing and good luck in the future. Thank you.
Thank you. I'm talking.